don't believe the rule of sequestration applies to him per statute, but I wanted to make the court aware that he is in the courtroom.
Okay, thank you. Mr. McKinney, any objection to that?
The defense has researched that issue and agrees with the state, so long as there is not prejudice. If there is any prejudice that the defense sees, obviously we would make the timely objection.
Okay, thank you.
And the state would believe that would apply to any witness, so we would expect that.
Okay. If we're ready for the jury, if you'll please stand for the jury. Thank you. Thanks for being here. We're standing for you. Yes. Thank you. Thank you. Please be seated. Welcome back, ladies and gentlemen of the jury. Thank you so much for being here. The first order of business is what we call the rule. It's the rule of sequestration. So for any potential witnesses that are in the courtroom, each of you who may testify as a witness in this case, the court has invoked a rule of procedure which requires your exclusion from the courtroom at all times except during the time when you may testify in this case. You are directed to remain out of the courtroom except when you are called to testify. While you are waiting to testify, and after you have done so, and before you are released, you are not to discuss this case or your testimony among yourselves or with anyone else, or allow anyone to discuss anything regarding this trial with you. You may, however, one witness at a time, discuss your testimony with counsel for either party in this case. Any violation of this direction may not only subject you to contempt of court, but may also disqualify you as a witness in this case. You will now retire from the courtroom until you are called. Counsel for each of the parties is instructed to advise each of their respective witnesses that are not present of the direction I have just given, and each of them shall be governed thereby. Another thing, Ken is filming, and he is not allowed to show any of your faces, so you don't have to be concerned about that. He can't film the jury. So I just wanted to let you know that up front. Also, as I had foreshadowed yesterday, the initial instruction is pretty redundant, both from what you've heard before. It's the same instruction that I first gave the veneer when you came in, but then it's expanded and it's redundant within itself as far as not disclosing any information, not looking up anything, doing any homework. Justice has to happen in this courtroom. And again, as we discussed yesterday, the reason why it's hammered home is because Jurors in the past have gotten in trouble for not following that instruction. So here's the instruction. To have a fair and lawful trial, there are rules all jurors must follow. A basic rule is that jurors must decide the case only on the evidence presented in this courtroom.
Judge,
Yes, sir.
I apologize for interrupting. May I approach the stage?
Yes, sir.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located
So a basic rule is that jurors must decide the case only on the evidence presented in this courtroom. You must not communicate with anyone, including friends and family members, about this case, the people and places involved, or your jury service. You must not disclose your thoughts about this case or ask for advice on how to decide this case. I want to stress this rule means you must not use electronic devices or cell phones to communicate about this case, including posting information on an internet website, chat room, or blog. Do not send or accept any messages to or from anyone about this case or your jury service. In addition, your cell phones or electronic devices must be turned completely off while you're in the courtroom. You must not do any research or look up any words, names, maps, or anything else that may have anything to do with this case. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're at the courthouse, at home, or anywhere else. All of us are depending on you to follow these rules so that we will have a fair and lawful resolution to this case. Unlike questions that you may be allowed to ask in court, which will be answered in court in the presence of the judge and the parties, if you investigate, research, or make inquiries on your own outside of the courtroom, the trial judge has no way to assure that they are proper and relevant to this case. The parties likewise have no opportunity to dispute the accuracy of what you find or to provide rebuttal evidence to it. That is contrary to our judicial system, which assures every party the right to ask questions about and rebut the evidence being considered against it. Non-court inquiries and investigations unfairly and improperly prevent the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of this proceeding, and a mistrial could result that would require the entire trial process to begin over. A mistrial is a tremendous expense and inconvenience to the parties, to the court, and to the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. If you become aware of any violations of these instructions or any other instructions I give, you must tell me by giving a note to the bailiff. Members of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Maria Rodriguez Barnes. This is a criminal case. Maria Rodriguez Barnes is charged with first-degree premeditated murder. The definition of first-degree premeditated murder will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Maria Rodriguez Barnes in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be introduced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with a final instruction. After the final instructions are given, you will retire to render your verdict. You should not form any definite or fixed opinion of the merits of this case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no posting information on the internet, emailing, or any other form of communication. You cannot do any research about this case or look up any information about this case. If you become aware of any violations of any of these rules at all, notify the court deputy of the violation. During the trial, court may take recesses and you will be permitted to go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, tell that person to stop because you're on the jury trying the case. And if that person persists, leave that person at once and immediately report the matter to the court deputy who will advise me. You cannot have any cell phones, tablets, laptops, or other electronic devices in the courtroom. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about this case or communicate with anyone about this case or the people involved in this case. Do not take photographs, video recordings, or audio recordings of the proceeding or of your fellow jurors. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're at the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at any maps or pictures to see any place discussed during this trial. Jurors must not have discussions of any sort with friends or family members about this case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about this trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages or ask for advice related to this case or your jury service. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in this courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper to this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered in this courtroom and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had that witness been permitted to answer. During the trial, it may be necessary to confer with the attorneys outside of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted to consume as little of your time as is necessary for a fair and orderly trial of this case. And I add a note above this standard instruction because usually when I start giving this instruction, the jurors' eyes start looking around the courtroom. So you will be provided with a notepad and pen to take notes if you wish to. So here's the instruction on that. And the end of this instruction I think is really informative. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceeding. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, you will be permitted to ask questions of witnesses in case you missed something, you did not understand something, or you need to clarify a pertinent issue. The rules of evidence apply regardless of whether a question is asked by an attorney, by me, or by you. Therefore, there may be a legal reason why I will not ask your question. If I do not ask your question, you must not hold that against either of the parties, and you must not discuss it with other jurors, and please do not take it personally. If you have a question, you should ask it before the witness leaves the witness stand. I have to smile, they added that to the standard instruction throughout the state because I asked them to. I had one juror that asked for a question of a witness that had already left the courtroom and was flying to Atlanta or somewhere. So if you have a question, and here are the instructions on how to do that. When the attorneys have finished asking their questions, please raise your hand to get my attention. I will then give you time to write your question on a clean piece of paper and give the paper to the court deputy. I will then confer privately with the attorneys. If I ask your question, the witness will answer, and the attorneys may follow up if they choose. The questioning of witnesses is the primary responsibility of the attorneys. If your question or questions is or not asked, you must not discuss it with the other jurors or hold it against either party. You are not obligated to ask any questions, but if it will help your understanding of the case, you may do so. There was one stipulation that the parties entered into, and I'll tell you what that stipulation is, and then the attorneys will give their opening statements. When lawyers agree that a certain fact is true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is the identity of the deceased alleged victim is Jackson Rodriguez Barnes, date of birth October 21st, 2019. And I don't have at hand the instruction on opening statements. Either of the parties have that. Got final instructions? And it's interesting because there are certain instructions, standard instructions that apply in civil and some in criminal. Sometimes they aren't the same.
Your Honor, can we approach?
Yes, sir. Thank you.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
And this is one of those opportunities. So the legal pad that you were given, if you will print your name on the first page of the legal pad, and then if you wish to take notes, begin those on the second page of the legal pad. So if you'll print your name on the first page, if you need any more paper or pen, please let the bailiff know and they'll provide that to you. And this is one of those instances where there is an instruction, it's civil but not in criminal, but basically, as I previously stated, what the attorneys say is not evidence. And so you're not to take it as such. Ms. Sandler, are you ready for an opening?
Yes, Your Honor.
Thank you.
I'm sorry for what I'm about to do. The evidence will show that was the last real phone conversation the defendant had with her husband. On March 25th, 2020, Maria Rodriguez Barnes drove her infant son to the boardwalk where her husband formally proposed. And the timeline evidence will show you that shortly after she said, "I'm sorry for what I'm about to do," she hit send on a note she began the night before, put a gun to the side of her infant son, and shot him in the back seat of her truck. She let his little body fall to the floorboard of the truck. The evidence will show that Ms. Rodriguez Barnes decided at least the day before to take the life of her child, the physical representation of the future she and her husband tried to build together, because that future was evolving in a way she simply didn't want. The evidence will show that this was a calculated and premeditated murder of a helpless 5-month-old infant in response to a request for a divorce. The state will show you through body cam footage and photos the scene. The state will show you the note found in her truck and the center console left to her parents. The state will show you that she began a note to her husband the day before the incident, long before she sent it to him. The state will show you plenty of evidence of the time spent in preparation of killing her son. The state will give you forensic evidence to show that there was one purposeful shot for Jackson Barnes. The state will show you how his death was intentional, and the state will have evidence that his death came from Ms. Rodriguez's gun. The state will also show you that it could not have been anyone else. The state asks of you during the course of this trial to pay attention to what Ms. Rodriguez did to Jackson Barnes in this case. The state is going to focus on showing the elements of the crime to you this week, because what matters is the evidence that proves Ms. Rodriguez committed first-degree premeditated murder in her plan and her actions to take the life of her infant son. At the close of this case, the judge is going to give you the law, and the state is going to ask you to apply the facts to the law, and the state will come back and ask you to render the verdict that the evidence dictates and that justice demands, and ask you to find Ms. Rodriguez guilty of first-degree premeditated murder for the shooting death of 5-month-old Jackson Barnes.
Thank you. Mr. McKinney?
May it please court, state, ladies and gentlemen of the jury, this is obviously a serious case, and it requires serious attention. The evidence that you're going to see starting today is going to be graphic in nature. The charge from the defense is to remain objective. Hold the state to their burden, and keep in mind that the state must prove their case beyond a reasonable doubt in each element. And we will circle back around and talk about specific elements in closing. Do not form any fixed or definite decisions as you view this evidence. Wait until the end. This is the beginning of the trial, not the end. And we will have a second chance to talk after you have seen everything, and then you will render a decision. Thank you for your attention.
Thank you, Mr. McKinney. To the state, your first witness.